A very warm welcome to all. Today, I, Reeya Khanna, a legal intern under LEXIS and Company, am here virtually to explain my topic, Impact of Social Media in Law of Evidence. Our ability to communicate through language and gestures gave us human a distinct evolutionary advantage than other species. We humans are social beings and we need social interaction. Technology has simplified our lives and it has also changed the way we communicate these days. India has one of the highest numbers of internet users and the highest social media presence in the current scenario, and this will only keep on increasing. These days, almost everyone owns a smartphone which comes with a package of pre installed social media and other apps. With just a few clicks, and your online profile is created. It is due to this convenience that there has been often misuse. With great and new increase in technology emerges a great and new kind of crime called cybercrime. Cyber stalking and online harassment is very quotidian occurrence in the world of social media. The veil of anonymity gives these perpetrators a false sense of security. And in this techno-savvy day and age where an individual is heavily dependent on this highly digitalized world of e-commerce, e-business, e-governance, e-procurement, and emails, laws related to cybercrime is the need of the hour. Information Technology Act 2000 was one of the first steps India took to address various offenses related to the cybercrime. IT Act 2000 incorporated not just any and all conceivable cybercrimes against a person, but also included cybercrime against government and property. It also encompassed laws related to not only cybercrimes but intellectual property, data protection, and privacy too. Offenses such as cyber stalking, impersonating, identity theft, violation of privacy, publishing obscene or sexually explicit matter, including that of a child, are all recognized as cybercrime against a person and are punishable under the Information Technology Act of 2000. Let us talk about admissibility of social media as evidence. Carl Sagan once said, absence of evidence is not evidence of absence. A crime primarily has four key components: mental state or mens rea, conduct or actus rea, concurrence, and causation. And to prove that one has committed a crime, the prosecution needs evidence. The burden of proof mostly lies on the prosecution, except in a few exceptional cases. In the eyes of law, a person is innocent until proven guilty. The guilt must be proved beyond a reasonable doubt. Evidence becomes an instrument to satisfy the court, to prove or to disprove a disputed fact between the parties involved in litigation. There are various forms of evidence. Other than the traditional forms of evidence like physical, testimonial, circumstantial, etc., electronic evidence has been accepted recently and is considered as a documentary evidence. Section 3 of the Indian Evidence Act 1872 recognizes electronic records as evidence. Let us understand this particular aspect with the help of a case law. In 2017, the Haryana court recognized WhatsApp chats as evidence to convict three law students of rape. The three former students of O.P. Jindal Global University were held guilty for blackmailing and raping a student of the same university for 2 years. ASJ Sunita Grover said that the messages proved that the victim was forced to keep sharing nude pictures with the culprits. The court considered the chats as documentary evidence supporting the victim's statement. However, in another incident, Justice Sanjeev Sachdeva observed while hearing the petitioner for registering the FIR connection with an alleged suicide note claimed to be of Arunachal Chief Minister Kalikopul. A WhatsApp post does not qualify as legal evidence, especially when neither the original nor a copy of the original document is produced. Such a form of evidence needs corroboration.